and welcome to Uprisings. I'm Muriel Krabs, and I have with me today attorney Tim Colgan. Tim is here to talk about a sort of an exciting, pretty new approach to law, which is called collaborative law. Now, I recently took this course a couple of weeks ago. First of all, Tim, tell us where you're from. Where is your office?
I have 3 offices, an office in York, an office in Dillsburg, and an office in Harrisburg also. And our practice is 5 attorneys, and we cover a variety of different practice areas. My practice area happens to be family law, though. Okay.
So family law is just basically you're out there being the champion of one of the two's case, but that's not the same in collaborative law, is it? Or
well, collaborative practice is just a different style of helping families who are going through either issues of divorce or custody or matters of financial support. Mm-hmm. And rather than the more traditional style that everyone thinks of is where 2 parties go to court to have either a judge or a divorce master decide their issues for them, in collaborative practice, the parties themselves pledge to take over that process and to reach their own agreement. They intentionally pursue settlement rather than letting a third party make decisions for them and reach resolution for them.
It sounds. I sat and took the course. It was a two-day course, and they had included a psychologist in the whole program. But I do a fair amount of domestic work myself. And to let people know sort of the process, many times the cases begin with someone filing a divorce complaint and then filing a complaint for support and a complaint then perhaps for the custody of the children, and then a request for an appointment of a master and get information together to go forward, to go before a master and argue about assets. And this process, all of that can be pretty expensive, I know, emotionally draining, particularly the custody, don't you think?
Sure, and that's one of the major drawbacks to the litigation side of things is I'll tell the clients of mine that there is a tremendous financial expense to going through that process, but there's also, as you had said, a great emotional expense that goes along with it as well. And it tends to be inefficient because parties don't agree up front to share information or to basically get down to the essential elements of dividing up what the 2 of them have accumulated during their marriage or making decisions about the best way to parent their children going forward. So collaborative practice is different in that the parties agree up front that they are going to work together to arrive at a resolution, and it's a pretty structured process. They're not doing it inside of a courtroom, they're doing it inside of a conference room or a meeting room with an attorney representing each individual spouse. And you can also have additional team members too, a child specialist or a financial specialist or appraisers to help the spouses decide what values they're going to place on particular assets that they have.
Now that sounds as if it could get pretty expensive too.
It can, but I think it's compressed expense. As you know from going through the litigation process, there are lots of starts and stops. There can be very expensive periods, and then there can be long stretches of time where nothing is happening and there's not a lot of expense. In a collaborative process, the process itself is much more condensed than a litigation case would be. So my experience has been that most cases resolve in anywhere from 3 to 6 months as opposed to the many years that they can drag out in a litigated situation. And so, yeah, the expense is going to be compressed and it's going to be condensed into that period of time, but overall it tends to be less expensive, has been my experience, because we're not having dual experts. We're not having 2 experts appraise a house or appraise a business. We're not having 2 different financial professionals value pensions. The parties can agree that, yes, there's an asset that they may not have the expertise to determine its value, but they can agree to hire one individual to help them establish that value. So it eliminates duplicate expense, and it's also all of the money that's expended is in an effort to move the case forward to an ultimate resolution. You do away with so much of the procedural aspects of divorce and custody cases that don't really advance the parties to any kind of final resolution. The fighting over things like who's going to produce which pieces of paper or which documents, or who's going to get information on bank statements and mortgage statements. The parties pledge up front to produce all of that at the very beginning of the process, at the inception of the process.
Well, let me, because the collaborative law is relatively new, isn't it?
It's 20 years old. It was started in Minnesota in the late 1980s by a gentleman named Stu Webb, and it's expanded across the globe. It's really exploded across the world in that 20-year period. Relatively new in Pennsylvania, though.
And tell me when and why you decided to become involved in it.
Well, I think in talking to other trained collaborative professionals, you find that it probably blends with your own style of practice and your own way of doing things. I find myself being somebody who would much prefer to get down to the ultimate issues in a matter rather than spend time playing procedural games or just trying to delay or stall and do tactical things along those lines. We had a discussion about that, and what advantage does that offer to your client in doing those kinds of procedural maneuvers. That wasn't my style as a litigator. It continues to not be my style as I still do litigation cases, and it's certainly nothing that is an element of the collaborative process.
Right. It's funny you were saying that. I'm thinking of the exact same thing. When we talked about how a divorce begins, very often when someone comes to me about getting a divorce, I encourage them to go back and talk to the spouse about some of the issues that they can get cleared away before that spouse receives a divorce complaint that has this huge notice, you're being sued, and then all the boilerplate things in there, which she wants attorney's fees. I have guys come to me, she wants me to pay all of her attorney's fees. She wants me to, just because he's gotten this divorce complaint, and immediately the conversation is stymied. They're
Absolutely.
so upset that they can't see straight. Now, on the other hand, I've had women particularly come to me and they say, well, he wants me to take this and this and this, and I just want it over. And I can tell the individual is so distressed that it's just not a good idea for her to sign on the dotted line
Sure.
about everything being distributed.
Right. So the collaborative process is different in a couple of ways. One, I often analogize for people that it's like it dispenses with what you find in litigation a lot, which is what I would analogize to the bottle of ketchup. When you turn the bottle of ketchup over and the first thing you get out of it is that watery stuff and there's not really any ketchup there. Mm-hmm. So much of the initial part of family law matters tends to be that watery stuff. We do away with all of that and we get right to the ketchup immediately. And we also don't want people making those knee-jerk reactions. We don't want them negotiating for themselves out of a sense of either frustration or fear or an emotional low point where they just want to get it over with. Or sometimes I'm sure you've experienced people who are willing to give everything away because they're feeling guilty about something that they may have done. And that may be the most expedient way for people to deal with these issues, but it's not. If you ask them 6 months or 2 years or 5 years down the road, do they think that was the best resolution for them? I think you'd find most of them would say it was not. In the collaborative process, they have an advocate with them, someone to explain not only the elements of the law to them and the things that they may not understand, but also to make sure that they have negotiated from their highest and best self-interest to get a result that is best for them.
That's again, I just want to find out though from you initially how long you've been doing this, and when did you start? And
I was trained as a collaborative practitioner in the early part of 2007 and have been doing that ever since. And I'm also a trained mediator as well.
Okay.
So mediation is a little different because if parties decide to mediate their dispute, and it's done as family law cases are mediated as well as all other kinds of disputes. Mm-hmm. But in a mediated case, the parties decide that they're going to hire one neutral third party. That neutral third party is really there to facilitate the discussion between the two of them. Mm-hmm. It's not somebody there to advocate for either spouse. Collaborative is different in that each spouse has their own collaborative lawyer who works with them in order to help them reach resolution.
There's so many questions that I have as an attorney how this works when you are actually sitting. You have a client who says, well, I guess perhaps you can just explain the process. I mean, and let's do this after the second part of this program, because I think once we sit down and go through the whole process, it'll take our viewing people, through it and understand how it could all possibly occur. But how many collaborative type lawyers do we have in York County?
In York County, there are probably 5 to 10 collaboratively trained lawyers, and that group is growing all the time. Several took the training with you that you just went through. And then in the central Pennsylvania area, there are well over 40 collaboratively trained professionals. And we're all part of a practice group in central Pennsylvania that are known as the Collaborative Professionals of Central Pennsylvania.
Collaborative Professionals of Central Pennsylvania.
Right.
You have a website?
There is a website. It's collaborativelawpa.com.
Okay.
So people can go to that site, get a lot of information about collaborative practice here in the central Pennsylvania area. There's also an international organization called the International Academy of Collaborative Professionals, IACP is their acronym, and their website is collaborativepractice.com, and that has a wealth of information, articles, other resources for both professionals and also individuals who think that they might want to explore more about collaborative practice.
Okay, so if anyone is interested in the, say, York area or Adams County area, when I asked about York, does that include Adams, the 10 to 12 or whatever? It
does. And there are many who may have an office, say in my office is in both York. I have 2 offices in York County, the one in Dillsburg and then one in the city of York itself and Harrisburg. But I practice in Adams County, I practice in Perry County and Lancaster County. It's one of the things that collaborative offers too, is it doesn't limit folks geographically the way maybe a litigation practice would.
Oh, so that, an attorney who is in Hanover, say, can go to Harrisburg, which normally doesn't, and work with another collaborative attorney.
Sure, right. And the reason why people in Hanover may not go to Harrisburg is because procedurally every county is different. The law in Pennsylvania is all the same, but how the law functions and how the wheels turn is different. So
yeah, that's a whole nother thing,
right.
As they say. And the difference is when someone comes to me talking about custody, the first thing, okay, which county are you in?
Right.
Because that definitely is impacted. Now, the cost of the custody litigation, the time before which you actually see a conciliator or the judge. I can see why you would be, and as I was interested in the collaborative, because it is wearing to have to deal with the different court systems and keeping those balls up on juggling. But
let's talk about that for a second.
But we only have a second, so
okay.
Let's do this. We're going to come back and discuss it further, because it is really very interesting. So we'll be back in a minute, and you're with Uprisings. Thank you for being here. Hi, welcome back to Uprisings. I'm with Tim Colgan, an attorney who is involved in collaborative law. We've had a little conversation about it, but one of the things that we talked about right when we were going to break was the language of collaborative versus the practice of law.
Right.
And you were explaining how some of the words that we use, for instance, divorce and custody, can sort of ratchet up the emotions that are involved in this.
And it happens a lot where people are fearful of what their spouse may be doing, so they feel like they need to take a super aggressive stance, and then their spouse answers in kind with an even more aggressive stance, and before you know it, they've gotten to a point where really the case has spun out of control, and you'll talk to them after the fact or when it's gotten to that level, and they'll say, boy, I didn't want it to get to this point. I wanted to be able to do this amicably, respectfully, but I felt like I had to protect myself, and that was the only way that I knew how. Collaborative gives people a different option. At the beginning of the case, they pledge that they're going to resolve their differences between themselves, that they're not going to ask the court to get involved in that, and they're not going to threaten to use court to get what they want out of the process. They're going to negotiate from their best interests and for themselves, for what they need and what they're interested in, not by threatening or intimidating the other spouse.
So you've had to learn to use different language yourself as an attorney.
We do, because as attorneys we use language like divorce masters and custody conciliators and hearings and motions and pleadings and things that are all terms that are not part of the everyday language of most folks, and they're intimidating words. They're words that frighten people. And for families, what they're really doing is they're going through a restructuring of some sort, and they're talking about issues of cash flow, not their words aren't child support and alimony and things like that. They're talking about, how am I going to make the mortgage payment this month, or how am I going to survive on what's left after after cash has changed hands. So, and they're not talking about things. They don't think in terms of custody. They think in terms of, what's the best arrangement to parent our children going forward? I want what's best for my child, and my spouse wants what's best. We can have a good faith disagreement about what that looks like and what that schedule is going to be like, but we both share an interest in seeing our children do well and having our children have good, healthy relationships with both parents.
I think it might be easier for people to envision sitting at a table, and by the way, I can't tell you, ever all the years I've been practicing, where people have said to me, can't we just get together with his lawyer and work this out? And,
right.
And you know, it just normally doesn't work that way. But you know, collaborative law does. So it's easier, I think, for people hearing this and listening to this to see that, yeah, I think this is a good idea.
Right.
I am having difficulty as an attorney. There's little things that keep cropping, like for instance, all right, you have a client, she comes in and she says she wants collaborative law, and you call and you give her a list, I guess, to give to her husband of other collaborative lawyers. Is that correct?
Correct.
And then they call me up. So he calls me up and he says, will you represent me? So now we're in a collaborative law situation. I explain, I mean, when I do divorce, I always start out with what I call Divorce 101. I sit with my clients and spend an hour explaining the divorce code, equitable distribution, custody support. You know that they're all entwined, which
right.
is...
And what you're doing when you talk to people about that is you're telling them what the law is going to do to them.
What the court will do. And I say that generally the court, you know...
Right. But people are free to make their own agreements, provided it's not illegal or against public policy for some reason. The court system is there in all respects when people can't resolve issues on their own. It's the fallback. It's not what must occur. It's what occurs when people can't reach their own agreement. So sometimes people want to know, what would happen if I went to court? What I find is people believe that there is a yes and a no, or a black and a white about it, that there is only one answer or two choices. And you know that the law is far grayer than that. It's very difficult to predict for people what might happen when they go to court, whether it's an issue of custody or whether it's the division of the assets or the division of their debts. You can give people general ranges, but to give someone an absolute prediction, we're unable to do that. And that's unsettling for people. You'll find, and I'm sure you do find, that people, that creates a tremendous amount of stress. The unknown of letting some third party, whether it's a divorce master or a judge, decide their future is tremendously stressful. And removing that stress by participating in the collaborative process, it peels away an entire layer that really stands in the way of people reaching agreement. Now people can talk about certain things like, boy, I really think it's important for the kids to stay in the home that they're in because it's the only home they've ever known, or it allows them to continue to attend the same elementary school. Do you share that same sense with me, you know, my soon-to-be ex-spouse? And if yes, then is there a way that we can solve that problem? Can we make that happen? Is it financially reasonable?
And again, I can see how that all makes sense. But what is the role of the attorney in that? When two attorneys are sitting in the same room with these clients who are...
Sure.
And I understand, again, I took the course, but I'm thinking about, for instance, if you say, you have an agenda, let's talk about what to do about the kids, what to do about the house, what to do about the pension, what to do. And I could see going through these issues and then letting the clients discuss it, and maybe, but how much does the attorney in that whole process get involved other than sort of an educational and structural thing?
Well, from a couple of different standpoints. Let me give you an example. This happened just in a case last night that we were able to resolve, and it was at the end of our 4th meeting, a case that started in September. These folks now have a comprehensive agreement after 4 meetings, far faster than any other approach that they could have taken, and it's an agreement that they both feel good about and feel like it was an agreement that was out of their own choosing and out of their own creation. However, one of the things that they were talking about in this agreement was setting forth a schedule of child support that was going to child support and support for the dependent spouse going forward, but it was tied to graduation dates for children in high school, that it was going to drop off at a certain point. And so they were calling part of this child support and part of it alimony. Well, they didn't understand or didn't know that what the IRS is going to say about that alimony piece is that if it's tied to a child's graduation from high school, it's really not alimony, it's child support. And so part of what they were talking about, they wanted a portion of it to be considered alimony because it was tax deductible to the husband. But what they needed to understand, and I represent the husband, what he needs to understand is that there's a chance that if they do it in that way, while that's a novel idea or a novel approach, they may have legal difficulties down the road. So that's an element where, as a lawyer, I'm advising my client that, okay, that's an option that you're talking about. You have to understand going forward what the potential pros and cons of that option are.
One of the real sticking points that we have in just basically in domestic work is the fact that we have a schedule of support. It doesn't matter what anybody's expenses are, or very, very, very little influence on special needs. It's all about how much money does this guy net or she nets from her pay at work. Of course, they give it to the government first, they get theirs, and then they say, okay, now what you have. And so many times, and I know you'll recognize that support is the engine for all this other stuff. So the father who really is more comfortable with seeing the children after he works a couple days a week and on the weekends ends up saying, if I had her 50% of the time, then the support guidelines, and they're called guidelines, but they're treated as though they're etched in stone.
Right.
So now.
And they're completely one size fits all. There's nothing tailor-made about that guideline for any family in Pennsylvania.
Exactly. Now, and the other part of that is that the court will enforce the support guidelines versus an agreement between the parties.
Sure. And
so how do you handle that? So let's say your client agrees to pay her $800 a month, but the guidelines say he would pay her $1,200 a month, and she signs this agreement, and they're all agreed, everything's okay, and then about 2 years later she says, I think I'll just go and get the guideline amount.
It's something that we discuss as part of the process. What is your comfort level with having that as an informal agreement between the two of you? And you need to understand, again, this is where the role of the lawyer comes in. You need to understand the difference between an informal agreement versus an agreement that's submitted to the court for enforcement purposes through domestic relations. And we have that discussion with folks. And in fact, sometimes we agree as part of the process, the fact that they're pledging not to go to court doesn't mean that they're pledging not to use the court system at all. They can agree that, boy, it would sure give me a comfort level if I knew that that agreement was recorded as a court order, so that I don't think you're not going to pay, I don't think you're going to try and avoid your obligation, but you're saying you're going to give me $800 a month. It would make me feel a lot better if we could have that recorded as a court order. And that's something that the parties can agree to do, and then we go ahead and we do that. We file the divorce complaint in the same way. They maintain control over when it gets filed and where it gets filed and when things get finalized. So the process itself, we're pledging not to use the court system to make decisions for the parties, But we're not pledging to avoid the court system in its entirety, because it certainly has a very important purpose and a very important role in the whole process.
Mm-hmm. How has the bar been accepting or toward you? Or, I mean, it seems to me we have a large domestic, what they call the domestic bar, and several are noted for their aggressive representation, sure. and that's really how they bill themselves, as, hey, you need aggressive representation. So collaborative lawyers may not be people they really want to have a beer with.
It's interesting. There are a lot of folks who are members of the collaborative practice group that I'm a part of, who are exactly the kind of folks you would have thought, boy, I would have never imagined that they would have wanted to be a collaborative practitioner. What I've learned is that while they've got this aggressive exterior, what they really understand is that they're being used as a weapon in blowing families apart.
Right.
And we have skills, we have knowledge, we have something to add to this process. There's no question that families are going to restructure. There are going to be divorces. There are going to be disputes over parenting arrangements. Isn't it time that we use the skills and the knowledge that we have as a constructive force in helping these families move forward, rather than being a weapon to blow people apart?
We go to church every Sunday, and you hear this, what God has put together, let no man put asunder. And I've been in church thinking, geez, am I going to hit by lightning here? Because you're right. I mean, that's really what we do.
Right.
And I have to admit, I mean, there have been times that I've encouraged clients to go back and just try to work it out, but I'm never really that good by the time they get to the lawyer generally.
Sure.
All right, now we only have about a minute left, so 30 seconds as it turns out. So, is there sort of a last thought that you have about the collaborative law process? What you can?
I think the most important thing is that it's not. It doesn't replace all other forms of dispute resolution. It's another avenue that is available for people. It's something that I think is a very powerful tool that's out there for people. It's something that I would encourage people not to dismiss it. A lot of times people will say, that sounds great to me, but my spouse would never go for it. Mm-hmm. And I would say, don't dismiss it out of hand. Read about it. Go to those two websites, collaborativelawpa.com or collaborativepractice.com. Read more about it. Share the information with your spouse. Give it a chance, because it's a better way. You don't lose anything if you try that method first.
Well, thank you very much.
Thanks for having me.
Oh,